Hello, good day everybody. Welcome to my webinar on negotiating or renegotiating a dental office lease. My name is John Babatinka and I'm with a company called Cirrus Consulting Group. And for over 2 decades now, we've been providing dental office lease support to dentists across Canada and the United States, helping them effectively deal with this important part of the dental practice, certainly one of the most expensive parts of running and operating a successful dental practice. And the purpose of today's webinar is to dig into this component of the dental practice and to understand it a little bit better. So whether you're starting up a practice, renewing a lease agreement for an existing practice, expanding your dental practice, potentially relocating, planning a transition sometime in the next 10 years, or even if you own your building and have your practice in your building and are looking at how to better understand how better to structure a relationship between your building and practice, today's program should be fairly insightful. So a little bit about us before we get going, because I think it's quite important that you understand who we are and why it is we're providing you with the content of this webinar today. Cirrus Consulting Group is a firm that was founded back in 1994 by dentists for dentists to help the dental community more effectively negotiate their dental office leases with landlords who on the other side of the table are professionals at ensuring that every day they get the very best deals out of their tenants, including dentists. And over the last 2 decades since we've been in business, we've been involved in negotiating over 10,000 dental office leases. We represent and act for over 1,000 dentists a year across North America. We have an in-house legal, leasing, and consulting departments that all weigh in on ensuring that the lease agreements and the real estate strategy for the practice fit the doctor's life plan as opposed to wrapping their life plan around some arbitrary document called a tenant lease. We do over 150 courses a year across the country, ranging from some of the largest lecturers in the country all the way through regional conferences, local programs, and study club meetings, and everything in between, and of course webinars like the one that you're on today. And finally, we work with dentists in every state in the US as well as every province in Canada. Just some of our recent clients are here. Really, our goal is to educate and help people to get a better deal. So the purpose of today's seminar, it's really to tie in and hammer down the importance of the office lease agreements and really talk about how the dental office lease is more important a document in the dental community as a segment of the small business population of North America, as opposed to just about any other small business tenant, whether it's healthcare related, family physicians, veterinarians, or whether it's non-healthcare related, so accountants, legal offices, insurance offices. So today we're going to talk about why the dental office lease specifically in this industry is more critical a tool and component to helping and grow and preserve and eventually sell the value of the dental practice. We're then going to dig into a couple of key terms in lease agreements, and we'll get into a little bit of practical advice and strategic advice on how to position oneself and time oneself into getting ready to start a negotiation and really preparing and planning to succeed and get the most value out of the lease negotiation with the landlord. So before I get going, I ask this question quite often: what is a lease agreement? And a lease agreement is two things. Number one, and the real sort of technical answer, is that it's a agreement between two parties, a landlord and a tenant, that spells out specific factors and variables involved in tenancy. So for a landlord, what they're interested in knowing is who the tenant is, how long they're staying for, how much they're going to pay, what obligations they have. And for a tenant, a lease agreement is important because, again, very similarly, tenants want to know where the property is, what specific space they're renting. They want to know what the cost of that space is in year one and how much that cost will increase over time. They want to know how long they have an ability to stay in that space by way of options and terms. And there's all kinds of other flexibility that's important in a lease agreement that we will get into. So another question that I ask quite often in my seminars: what is the single biggest financial commitment that a dentist will make in their life? And now, most people typically raise their hands and they say, well, it's when I buy a home, and that's the single biggest financial commitment or purchase that I make. And the answer is that's correct outside of the dental world. But in the dental world, the single biggest expense that a dentist has in their life is as it relates to the occupancy expenses of their practice. When you add up the amount of rent that gets paid by a dental tenant over the lifetime of one's career, call it 25, 30, 35 years, perhaps even longer for some, When you add up that amount of money, it's a staggering number. It's huge. Now, I'm not being critical and saying that it's not the right way to go or the right path, because it's a wonderful thing to be able to rent space and then use that space in somebody else's building to run your own small, successful business. But the purpose of me telling you that a lease agreement is a check is simply to help you understand that you're spending a lot of money with your landlord. You're spending a tremendous amount of money with them every 2, 3, 5, 10 years, every time you renew on a new documents and agree to spend more money with them. And really the goal here is to try to figure out how to get as much mileage as you can out of that very big purchase. And yet somehow this phenomenon, as it relates to lease agreements, we agree to write these checks, to sign these long-term commitments with the landlords, and then we go ahead and sign a 30, 40, or 50-page lease agreement with all types of terms and conditions without really fully trying to understand and figure out, aside from this rent per square foot, how do we get the most mileage out of this commitment? That's something that we as a group of tenants have not done well over the years. And it's one of the things I try to teach tenants is that you're spending a lot of money. Just like any other aspects of your life, you should be trying to get the most mileage out of this commitment that you're about to make with a landlord, or recommitments if the lease agreement is a renewal. So why is the lease agreement more important in the industry of dentistry than in just about any other industry that exists? Why is the dental office lease a critical component of gluing together all of the value of the practice over time? And the first point I want to talk about is the fact that dental practices are tremendously expensive assets to acquire or to build. When we typically get out of dental school, we go and find an associateship for a few years. We spend a few years associating, then we typically get to a point in the life cycle of the average dentist where we're ready to acquire our own practice. Now, how do we get into owning our own practice? One of two paths typically. We either, number one, build a practice in an empty space. So we rent it, build it, open it up, and then start to grow it from zero in production upwards. Or path B, we find an exiting or retiring dentist somewhere in the community. We buy the practice from them, take it over, and run it. Either way, whatever path we go down is, number one, expensive. It's very difficult to pick up a dental practice and to move it. And if somebody chose at some point for us to take the keys to that space away, it would take a significant amount of time to find a new home for that practice, to relocate it. This is not a get the keys taken away on a Friday and be open in a new location across the street on a Monday kind of business that we're in dentistry. And unfortunately, in many parts of the country, the timelines to go through a practice relocation are anywhere between 8 and 12 months, and sometimes longer. So, because of all the things that are referred to and the restrictions on the asset, which is the physical plant, the dental practice, the box where the plumbing and the electrical are plugged into, and that typically runs under a few inches of concrete. We have cabinetry that sometimes perfectly fits with the operatories in that particular space. We need to make sure that when we sign or re-sign commitments with landlords, that we're doing so in a way that gives us the most amount of room or runway available ahead of us to ensure that our practice does not get disrupted, certainly does not get disrupted by surprise, whereby we're either at the end of the track, the end of the term, or we're not at the end of the term, but somehow the landlord has put themselves in a position where they can replace us with another tenant who wants to pay 50 cents a square foot more. And so long-term stability and security is key. And what do I mean about that? By that? So what should the office lease agreement be doing for you? Well, there are many things that the lease agreement should be doing for you. First and foremost, we shouldn't be signing 2, 3, and 5-year leases, generally speaking, in dentistry. We should be signing 10-year leases plus as many 5-year options to renew as we can get as part of our negotiation strategy. Number 2, we should be trying to minimize the risk and exposure we're providing to the landlord. I was just on a call recently with a dentist in Southern California. 50 years old, is relocating his dental practice. He's received 3 proposals from other landlords for new spaces, and every single one of those landlords refer to him as under the tenant line by his name personally. It actually said, and I'll make this up, it's not his real name, Dr. Jim Smith, DDS, an individual. So all those three proposals reflected that Dr. Jim Smith would personally be liable and he would be taking on a significant amount of exposure and liability by agreeing to sign the lease personally. So if you signed a lease personally, and I would like you all to check your lease agreements after this webinar today, what that means is that if at any points there was a default on the lease and or yourself and the landlord ever got into any kind of dispute over anything, the landlord could pursue all of your family assets to recover damages. Now, as we get older as dentists, we pay down our debts, we start to build up our net worth, our asset value over the lifetime of our career. We have more and more to protect than we did in our 20s and 30s, certainly as we get into our 40s, 50s. So it is critical that we carefully manage that component of the lease agreements. Now, what is an alternative way of signing the lease agreements? Well, I'll point you to your lease agreement and ask you this question. When you take a look at your lease agreement, who is the landlord? Is the landlord on your lease agreement an individual name of a person? Or is the name of the landlord on your agreement some type of corporation, some type of incorporated company, some form of LLC, limited liability company? And the answer is that 98% of the time, landlords, when they're even remotely sophisticated, know that these are not documents that they should be signing personally because there's far too much risk and exposure. And one of the things that this webinar is here today to teach you is that you too should be using that knowledge to understand how to sign dental office leases and how not to sign dental office leases. So next point, the dental office lease should help you maximize your flexibility. So how do we do this and why do we need flexibility? Well, it's very simple. I'll give you a couple of examples of real-life flexibility that a typical dental practice needs today. If any of you at some point are considering that you may sell your dental practice anytime within the next 50 years, you need flexibility built into your lease to enable you to sell that practice. If you don't have language in the lease agreement that gives you the ability to transition out of the practice and transfer the lease agreement out of your name and into the name of the buying dentist who's interested in your practice, you're going to have a problem. And so that's one example. And by the way, we'll look at that particular clause in just a few minutes, so hang tight. Another example of maximum flexibility is a dentist that goes and signs a 5 or 10-year lease agreement because that's what we suggested and that was the right way to go. And then 2 years into that 10-year lease, they're driving on the free day one day and an accident occurs. It knocks them off the side of the road and they die. So 2 years into a 10-year lease and now they're gone. They've signed this lease. There's 8 years of term left on the lease agreements. In other words, there's 8 years worth of rental payments that are still due to the landlord, whether the dentist is around or not. Now, what happens? Well, what happens is that the dentist's family or their estate is now saddled with having to pay 8 years worth of rents over the next 8 years, broken down month by month. And in the event that the rents do not get paid, the landlord, because the dentist signed personally, is now able to go after and sue the family or estates for the unpaid amount of rent that are still on balance. So how do you fix this problem? Well, one of the ways the lease agreement can provide a dentist with flexibility is by way of what we use or we call death and disability provisioning. And what death and disability provisioning does is it enables a dentist or his or her family or estate to terminate the lease agreement early in the event of a catastrophic incident. So if something catastrophic occurred, we would be able to turn to the back of the lease, hit the proverbial exit button, get out, pay a small penalty or small amount of consideration of the fact that we're getting out, and be gone and no longer have to spend years and years and years feeding that lease agreement. So that's another example of flexibility, and there are literally dozens of examples that should form the typical office lease agreements. Now, this is the part, the fair and affordable financial parts, the next point here, that most dentists in the country get tripped up on. And when I say get tripped up on, it's very simple. It's a smokescreen. It's a part of the lease agreement or the letter of intent that most dentists get laser focused And they really try to take the quoted rent or the asking rent and negotiate it downwards without any real clear sense of how far they want to go. And when we pull people aside and we ask them, what is your goal, what is your strategy here, they just tell us they want to get it down as much as possible. Now this is silly, because landlords, what they do then is just inflate their ask and figure out that if they're going to come down $2 or $3, they'll just build it into the initial price. And by the time they come down and the rent comes down $2 or $3, the tenant will feel like they've won something. And now the rest of the negotiations are over and the documents get signed. So the point of this is that before getting into any kind of rent rate negotiation, and again, whether it's for a startup practice for a new lease or whether it's on a renewal, do the research, figure out what's happening in the marketplace around you, look at what's happening by way of occupancy rates. Are they going up? Are they going down? Markets are dynamic. There's nothing static about commercial rents, and they never really stay the same in just about any market in the country. They're always either moving up or moving down, depending on what pace, either fast or slowly. And what you need to do is determine what the value of your space is, not based on what the landlord is telling you it is, but based on what the market suggests that it is, through the collection of research to help you better understand and determine what the market value is. Because the markets don't lie. The market value is what it is because it takes into consideration that different landlords have to compete with one another for their vacant space for new tenants, and then use that information to help position you to get a better deal. Now, the last thing I'll say as it relates to rents, if you make a mistake and overpay a landlord at renewal time, or even worse, at the front end of a new lease, that mistake doesn't just last for the first month or the first year. That mistake may follow you for the next 20 years of your career, simply because it's very easy to slip into allowing landlords to raise rents. It's far more difficult to somehow convince a landlord who you believe is overcharging you to step backwards and accept less money for the same product they're collecting money on today. So, critical points. And I don't want to gloss over this, but this in and of itself could be a 4-hour webinar. And then a last point, the lease agreement as it relates to transition is so critical. One of the single biggest referral sources we have here at Cirrus Consulting Group over the course of the year, and this has been going on for over 2 decades now, are practice transition specialists and brokers. So why? Because they are the ones that are tasked by the community to sell practices when doctors want to exit and everything goes great. So, a doctor will market a practice, they'll do an open house, they'll get people through, 1 or 2 people will raise their hands and emerge as the front runners. Somebody puts in an offer, that offer goes back and forth a few times, prices are agreed upon, that associate or buyer comes into the office, kicks the tires, pulls patient charts, takes a look around, they figure out whether they're comfortable with the practice, and if so, the lawyers now start to cross T's and dot I's, and then lo and behold, at the last minute, at the 11th hour, somebody remembers that they've got to ask the landlord for permission and approval to take the seller off the lease and put the buyer's name on the lease. And now this is where things get fun, because landlords have gotten and are continuing to get smarter over the years. And they know that when they're asked by a dental tenant of theirs to approve an assignment, that more often than not, a significant amount of money is changing hands. And sometimes, just sometimes, they want a piece of that action. So pay attention to the lease agreements, whether you're in your 30s, 40s, 50s, 60s, or 70s. Make sure that the lease agreement that you're on today or the one that you're about to renew or sign is transferable. Make it an asset to the sale of the practice as opposed to a liability. And we'll talk about assignment clauses in just a minute. Now, one last comment on this. And, just recently I sat in a lecture and I remember there was a speaker who was in front of a room of full of new grads and young associates. And one of the things that he said to them is that no matter how old you are and no matter what age you get into dentistry in your first practice for the first time, build your plan and everything around you. So the lease agreement, retirement planning, wills, etc. Make sure that everything is set up such that at some point you may go through an unexpected transition of your dental practice. In other words, be ready to exit and to sell anytime, because sometimes, and for some people, and certainly we met many dentists over the last 2+ decades that have been in these situations. Sometimes, despite the fact that you have a well-intentioned life plan of where you're going to be going and where you're going to be eventually retiring and how it's going to go and how it's going to look like and how much money you're going to have in the bank, sometimes life surprises us. And when that happens, it's better to be positioned and ready to be able to do what you have to do as opposed to be scrambling at that point. All right, so moving right along here, we talked a minute ago about the sale of the practice and being ready for transition. So I guess this applies more to general dentists than specialists, orthos, perios, endos, but generally speaking, what are the key ingredients that we're selling when we sell a dental practice? Now, those ingredients are number 1, the lease agreements, number 2, the patient base or the goodwill, and number 3, the equipments. Those are really the 3 components that make up a GD practice that formulate the bulk of the value. Now, if I was selling my practice and I listed my practice for $750,000 and a bunch of people came along and looked at it and said, yes, it's worth $750,000, no problem. Somebody came along and agreed to give me $750,000 for my practice. Then the very next day, the landlord either decided to terminate the lease agreement because they had the right to do so and give me 30 days notice of termination, or the landlord decided to force me through a relocation to the other side of the shopping center at my expense in 30 days. Is my practice still worth $750,000? And the answer to that is we don't know. We have no clue at that point what the practice is worth. The practice has had the lease agreement taken out from underneath it. It no longer has a lease agreement. It no longer has a continuity, that long-term stability and security that we talked about at the beginning. So now all of a sudden that practice that was nicely and tightly glued together over the last 20 years and was well in accordance with what the market was prepared to pay, $750,000, is now worth $750,000 on the high end, but unlikely anywhere close to that, and 0 on the low end, because now somebody has to come in and spend $250,000 rebuilding that practice elsewhere, whether it's on the other side of the shopping center or whether it's 2 blocks away in the only vacant space that they could find. So again, critical component of the practice. Now, I'm not suggesting that the dental practice, dental office lease is the most important part of the practice, because certainly I believe that the most important part of the dental practice is the dentist or the dentists that work in it, and everything else sort of cascades and falls below to support the dentist. But certainly the dental office lease formulates the foundation that holds the rest of the practice together, and it makes sure that it's not held together only long enough to enable you to get to the point of your career where you're ready to sell, but in addition, you want to make sure that you have enough term and options left to satisfy the condition that the buyer, who then has to go to the bank as a borrower and get them to lend money in order now to come in and buy this practice for you. They're going to have a requirement of a minimum amount of term. Typically it's 8 to 10 years. And if the lease agreement doesn't accommodate for that, the buyer is going to come back to you and say, I can't buy your practice. We have a problem. We've got to figure out how to get through this. So again, this pie graph represents a critical part of the typical dental practice. Now, I'm going to spend a minute here digging into the lease agreements, and there's a couple of clauses that I want to take you through. So we're going to get a bit technical, not too terribly technical. I don't want you to, walk out of here as a lease expert, but I want to give you a little bit of an understanding of the sections of the lease agreement that are commonly found in just about everybody's lease. So the first one we're going to begin with is what we refer to as the option to renew or the option to extend. And in this clause, and this clause is, by the way, paraphrased, of those over 1,000 dental office leases that we get sent to our office every year for analysis, this option to renew provision is typical of what we see in a dental office lease. So let me take you through some of the issues that are found in the dental office lease in this clause. So it begins by saying that provided Dr. Joe Black shall remain as the tenants. So first of all, the landlord is giving you an option to renew, but made it very easy for them to take it back. How? Well, it's very simple. As soon as the tenant is no longer the original tenant that signed the lease, Whether you're the original tenant or you bought the practice thinking there were options from another dentist who was the original tenant, as soon as the practice changes hands and gets transitioned from one person to the next, the options to renew evaporate. They are no longer there. So, big issue. Next, it states that so long as the tenant has duly and regularly paid its rent and performed its covenants and obligations under the lease and has not been in default. Now, here is the problem with this part. The landlord has tied your options to renew to you being in good standing and not being in default. The challenge here is this, that after doing this and being in business for over 20 years now, one of the things we know at Cirrus Consulting Group is that the average dentist defaults 4 times every 10 years. So let me just repeat that, 4 times every 10 years. Now, that doesn't mean that they run out of money and can't pay rent, because that's what some of you may be thinking, but it means that in sometimes the 40, 50, 60, 70 pages of clauses and conditions, there is something that gets missed or skipped, and it could be something as benign as the cleaners on a Tuesday evening when they're done in your space leave a bag of garbage in the hallway by mistake. They forget to come and pick it back up, and that's considered a default, and now you put the landlord in a position where they can take away your options to renew. It then goes on to say that the option to renew shall be, you shall provide the landlord no less than 9 months notice. Next issue here is that any such renewal shall be on the landlord's then current standard form lease. So you now exercise the option to renew. It's a new landlord who bought the property 40 years ago. They respond back to you and say, hey, thanks for exercising the option to renew. Glad to see you're sticking around for the next 5 years. By the way, you're now bound to stick around for the next 5 years because you've triggered that option. And by the way, here's attached 4 copies of our 162-page standard form lease agreements. We require that they get signed and sent back to us within 5 business days. Otherwise, you're in default. So what we've done here, ladies and gentlemen, is that we've agreed to whatever documents they come up with at the time of renewal. They're now in a position where they can send it to us, and we really have no rights to review it or negotiate without being able to get out of it, and that is an extreme problem. Now, it then goes on to say that it will go on to say that the minimum rent is to be determined between landlord and tenant, but in no event shall it be less than the rents paid in the last year of the original term. In other words, when you exercise the option to renew provision, the rents can only go up or stay the same, but they can definitely not go down. That's what we've agreed to in this highlighted text here. Now, here's the problem. Market rates are dynamic, as we talked about a few minutes ago. Rates and rents go up, they also go down, and it's cyclical. And if our renewal period or a term of a renewal or date ends up at the bottom end of the cycle, where we started paying off higher rents at the front end of that 5-year term or 10-year term, and now at the end of that term, the market rates are lower than what we're actually paying, we go ahead and exercise that option to renew. We've just artificially given the landlord more rent than we should for the market value of the product that we're buying. Because we agreed in this option to renew provision that rents can only stay the same or go up, but they cannot come down. This traps many, many, many dentists a year, and as a result costs sometimes tens of thousands of dollars a year, more than it should, because of those 8 or 9 words in that specific section. And next issue here, it then goes on to state that once we exercise, if we're unable to agree on market rents within 60 days, the rent shall be based on arbitration, based on the market rent for renewing tenants in the building. So that seems, fine enough. Now, what is the issue with that? What if the most recently renewing tenant in the building was a Starbucks? And what if that Starbucks, in order to renew, needed to go through a cosmetic uplift of their space and decided to spend $100,000 doing so, but instead of spending their own money, received and borrowed that money from the landlord in the form of tenant improvements, and agreed that they would pay the landlord back via a 20% premium to rent per square foot every year for the next 5 years until that $100,000 plus 20% interest got paid back. And now you're in a position where you've given the landlord the ability to base your renewing rents on what that Starbucks just paid, even though they get $100,000 and you won't be. So be very, very, very careful with your options to renew and what they look like and how they're written specifically to help landlords increase the amount of money they're able to achieve, improve their bottom line at the expense of tenants. Read these things carefully, because this is one of the most common traps and issues that we find located in dental office leases that ends up costing dentists a lot more money than it should. Now, the next provision here, and I'm sure some of you are very interested in this specific provision. I mentioned it a few times already. It refers to the assignment provision. Now, this is the clause that every dental practice needs in its lease agreement, and it needs to be properly structured. It's what makes dentistry different from just about any other dentist industry is that overwhelmingly in dentistry, there is continuity where the practice outlives the dentist that started it or runs it or owns it today, and therefore we need continuity built into the lease agreement to represent and account for that. So the assignment clause is found in about 75% of the leases that we review every year, and let me go ahead here and highlight some issues now. So first things first, it says here, if the tenant should wish to assign or sublet the premises, so if we are looking to sell, we shall first receive the consent of the landlord, period. Now, it doesn't say anything about the criteria that need to be met for that landlord to provide consent. It doesn't say anything about being unreasonably withheld or delayed. It just says that you need the landlord's permission. And by the way, based off the specific terminology, the landlord has the ability to say, based at their sole discretion, no thank you, we are not interested in giving you the right to assign. And I'll touch base upon why and how that happens in just a second. It then goes on to say, within 15 business days after receipt for such consent, the landlord shall have the option to either, number one, approve the tenant's request, number two, decline the tenant's request, or number three, terminate the lease agreement upon the effective date upon such a proposed as lease assignment or sublets. So let's take our eyes off this for just a second. What you've done, if you have this language in some way, shape, or form built into your lease, is that you've given the landlord an ability to make a lot of money in a very short amount of time, and let me explain how. So you're the seller of a dental practice. You go to the landlord, you ask the landlord for permission in writing to assign the lease agreement to a buyer. That landlord asks you a very simple question. How much are you selling your practice for? Now you say, it's none of your business. And the landlord says, let me try this again. How much are you selling your practice for? And by the way, it is my business, since you need me to consent to the request in order to enable you to move through this process and to actually sell and retire. So let me ask you again, how much are you selling the practice for? Now, at this point, you proceed uncomfortably to tell the landlord that you're selling the practice for $800,000. And the landlord, because of the language that's in red on your screen in front of you, says, here's what we're going to do. I'm going to give you two envelopes. Number one, you need to write us a check for 50% of the proceeds of sale, $400,000, and we'll give you permission to assign transfer. Now, you turn every color in the rainbow. You tell the landlord that's unfair, that's unethical, that's unreasonable. You can't do that. And the landlord says, here's the second envelope. By the way, read your lease agreements. We're going to give you 3 business days to determine whether you're in agreement with us that we deserve $400,000 to allow this to happen. And if you don't get back to us within 3 business days, we're going to give you the second letter. We're going to give you a termination notice for 30 days, which means that we want you out. And what we'll probably do is find another dentist that wants to come in the day after you're terminated, open up and start running your practice. So we'll leave that with you, doctor, and you can think about it and get back to us within 3 days. Now, this happens across the country more often than one thinks. because we at Cirrus Consulting Group here are the ones who get the calls when it happens, and it's happening everywhere, and it's happening with greater and increasing frequency because it's a very easy, quick, and by the way, legal way of making money when one is the landlord. So please read your assignment provision. If you're planning to sell anytime within the next 50, 40, 30, 20, 10 years, read the assignment provision. Make sure that if this language or any form similar of this language is somehow in there, that you've identified that it's in there and that you formulate a plan to get this language out. Now, it goes on to say, and there's many various issues in here, but for the sake of time, we're just going to focus on the last sentence in here. It states that the tenant shall not be released from its obligations under the lease agreement and shall remain liable for any failure of the tenant or the assignee to observe each and every covenant of the lease. So what does that mean? What that means is that now that the wound is open, and what the landlord is doing out here is that they're getting out the salt shaker and saying, oh, by the way, now that we've done this thing to you and taken money from your pocket for your hard work, your blood, sweat, and tears, and we've extorted you, and if we've done a very bad thing, you selling doctor are going to remain on the hook, which means that in the event that the young dentist that comes in, buys the practice at any point over the remainder of the term, so the remaining 8 to 10 years, defaults in any sort of way, we reserve the right to be able to come after you in retirement because we know that you have money in your bank accounts and that incoming associate for at least the next 10 to 15 years probably won't have lots of it. So that is a major, major problem. The assignment provision, folks, is really a clause that one needs to pay attention to in dentistry more so than any other small business segment in this country today. So key, make sure that this section is very well structured. Make sure you take a look at your leases after this webinar and look for the language that I've discussed today. Now, there's many other issues within the lease agreement that we believe are critical. Here's just a few of the key issues. You can see here highlighted a relocation clause. And we've just talked about the fact that landlords have language built into leases increasingly that gives them additional flexibility to move you elsewhere in the building. And by the way, if you think that the landlord is going to cover those costs, you should reread your lease agreement because it very clearly states that the landlord is only responsible for the moving costs and not building out and plumbing your space and putting that space back into dental condition. It's typically vague, it's typically omitted, and it typically would be at your expense and at very short notice. So big issue here. Another one we talked about, death and disability. All the way at the bottom right is financial statements. If we have any form of financial statement language in our lease agreements, we are giving the landlord the permission to ask us for our personal and practice financial statements unnecessarily. There is no reason in the world where we should be giving landlords exposure to this part of our practice. For example, how much money we earn, how much production, how much net income the practice makes, how much we take out of the practice every year. This information is just not necessary, and it doesn't benefit us in any way to provide the landlord with this information. So my suggestion is look at these clauses that are within this slide and look through your lease agreement. If there is any of these issues, if there are any of these issues, if you notice any language that doesn't seem right, you're going to want to highlight that. You're going to want to make a negotiation checklist and be ready to negotiate those points because really, you don't want to give them that kind of exposure and liability. Now, moving away from some of the issues for just a moment, I want to jump into the tenant lease cycle for a minute because I think that it's the single most practical thing that I can teach you on today's webinar is when to actually begin and start the process of negotiating or renegotiating a lease agreement. And I think that today, one of the major issues with dental tenants specifically is that, not enough attention is paid to the critical dates and when the lease agreement is coming up for expiry. And, there are tenants start the negotiation process with too little time between then and the end of the lease term. So as I said earlier, it takes 8 to 12 months on average to build out or move a dental practice in the country. So we know that it would take us 8 to 12 months. Let's go with 12 months that it would take to pick up and move our dental practice. And yet many dentists wait until there's 4 months left on their lease agreement to actually pick up the phone and start talking to the landlord. And if the landlord was half smart, they would know that you are not going anywhere. They would know that in order for you to go elsewhere, maybe to one of their competitors for a slightly better deal per square foot, that you would be down by about 8 months. You would be in the dark. There would be nowhere for your practice to open its doors and see patients for 8 months. And during that period, we all know in dentistry that if our lights are off and our doors are locked for even a week, let alone a month, or God forbid, 6 or 12 months, that patient attrition just continues to go up, and that is the last thing that we want. So critical point as it relates to the tenant lease cycle is the ideal time to start the process of renewing or renegotiating the lease is 24 months prior to the end of the term. So just going to repeat that. 24 months or 2 years is when we want to begin negotiations. Now, I would like everybody here today, look at your lease agreement, figure out the expiration date, and make sure that you start looking at your lease at least 24 months prior to the end of the term. Now, this doesn't mean that if you're 23 months or less, you're out of luck and there's no strategy for you to figure out how to get the best deal here. But what it just means is that 24 months provides you with the best opportunity to get the best results. Now, regardless, so just keep that in mind and mark that date in your calendar, put it on, tell Siri to give you a reminder, whatever the case may be, whatever works for you, but be very careful about that and be sure to note down that date. Now, this is something that I want to run through quickly. I know we're coming to the end of the webinar here, but it's something that we've developed here at Cirrus Consulting Group over the years, and this is the process that we go through when we get engaged and hired to help a tenant, a dentist, through a lease negotiation for a startup or a renewal lease negotiation. So it starts off in box number 1 by pulling together all of the documentation. So what does that mean? It means market rates, letters of intent, lease agreements, historical amendments, addendums, assignment, estoppels. Commercial real estate leases in general are incredibly paper intensive. There are lots of various documents, and you need to begin the process by gathering and pulling all the information together, because each of those documents formulates a piece to the puzzle, and only by looking at the entire puzzle completed as one picture will you really understand what the landlord knows about your tenancy, where it's going, and how to position yourself. And for these documents, I strongly recommend make sure you have backups in the cloud. Make sure you have backups, because the last thing you want, God forbid, is just to leave them in the office, something occurs to your office, and then you lose this documentation. So make sure you have backup copies of your critical documents. Now, step number 2, you want to identify what you're trying to accomplish as it relates to the lease agreements. What are you trying to achieve here? Number 3, review the lease agreement. Start on page 1 and end on page 40, 50, 70, or 90. Get out a few highlighters, read the lease and go through it by highlighting things that don't seem right to you and don't make sense to you, because quite frankly, that's what we do here, is we read the lease agreement from cover to cover, because that's the only way to figure out where the issues are. Because if we don't figure out what the issues are, how do we know what we're negotiating? We then layer in some market research where we go out to the marketplace and understand what's happening by way of trends, dynamics. Are occupancy rates going up? Are they going down? How about vacancy rates? What about rental rates? How much vacancy is there in your building, etc., etc. By understanding these dynamics and these aspects of the marketplace, we'll then know how best to predict what the landlord's going to ask for, and number 2, why they're going to ask for that number, and then number 3 is where should we be trying to push them to by way of a fair deal for both us and them. And number 5, again, we go back to what are we trying to accomplish? So what's our strategy? How old are we? Because when we're in our 50s versus our 40s, or versus our 50s, 60s, or 70s, We need different things that we're trying to achieve, different wins for different stages of our career and of our lives. And therefore, what we should be doing every 5 or 10 years is re-looking at what we need in the lease agreement and what we need the lease to do for us for the next 10 years versus what we needed it to do for the last 10 years of our career, because our goals and our priorities will change. And it's very critical to reflect that in the lease strategy. Number 6. So this is where we start negotiating with the landlord on the economics of your new deal, whether it's a renewal or a new deal. And what do I mean by economics? I'm referring to rental rates, rental rate increases, term, options to renew, all of those financial aspects of your deal, free rent, deposits, tenant improvement allowance, anything economic related now gets negotiated at step 6. Step 7. We now get into the lease agreement itself and the lease negotiation itself. This is where the landlord or the landlord's attorney sends us a copy of the document, and that's where we start to pull it apart, review it in the context or through the lens of what's in here by way of language that doesn't make sense. And if it's not right, we would never sign it. We would never allow a client to sign it. How do we want to position this negotiation to re-engineer that particular clause? And we go through that from one end of the document to the other. Now, once we've come to an agreement with a landlord on what the new document's going to look like, we then get things ready for final review. And that's when the landlord sends us, if they do send us final copies to be signed. We don't let them go to our client first. And it's very simple why. The reason we go through them again before our client signs it, because at the end of the negotiation process, even if you're doing this on your own or if somebody else is doing this for you, documents get prepped and they get sent to you. And what most people just do is they pull out their pen, they sign the documents, and they send them back to the landlord for execution. The problem is that nobody reads those final documents. And everybody assumed that the landlord was being honest and put into those leases exactly what was agreed upon in the previous 2 or 3 months of negotiations. And unfortunately, that's not always the case. And we only realized that we made a mistake by missing that step in the process 2, 3, 4 years later when something bad happens as it relates to the lease agreement. And it's too late because we go back, we open the lease, we read it, we look at it, we realize that there was something that the landlord did to us, like relocate us, and we noticed that it was actually in the lease agreement and it was put into the lease agreement before we signed. So again, we want to double check before finally signing those executed copies. So this process we'll let you see in front of you, it's not, it's like any other process in your business. It's the way that a pilot steps onto a plane and gets themselves ready to go through a pre-flight checklist. When you have a process, it gives you the best chance of the most predictable outcome. And this is the process that we use and that we've developed over the last 25 years. Now, last but not least, on today's webinar, we offer 2 services. One is when clients engage us to fully negotiate the lease agreement from start to finish, but I'm not here to talk to you about that today. What I would like to share with you today, though, is for any of you that have a lease agreement or for any of you that are looking to find a new lease agreement for the first time, we are prepared to review the lease agreement for you, and we are prepared to do it at no charge at all. All you need to do is get in touch with us. Let us know that you were on today's webinar. Let us know that you'd like us to review a copy of the lease agreement. And if the lease agreement is sent to us within 2 weeks of today's webinar, we will waive the usual $1,495 flat fee. And we will do that lease review for you at no charge as an attendee of today's webinar. So you need to reference the fact that you're on today's webinar, the date and the time of the program. Send us a copy of the lease agreement. We'll enter it into our system. We'll waive that $1,495 flat fee. And what we do is, it's quite simple. We spend several hours combing through your lease agreement, looking for issues, flags, traps that are in your lease agreements. Then we get on a call with you. We figure out a little bit about who you are, what your goals and plans are, and we'll then get into what we found in the lease agreements. We'll talk about how you can change or renegotiate some of those items that we found in your particular lease agreement as it relates to helping you achieve your goals. And then we'll help you come up with a proper negotiation or tactical plan to get the lease agreement negotiated properly. So it's a very valuable service. And for those of you that have a lease agreement, I would strongly encourage you to take us up on this because it truly is a wonderful program. Now, last but not least, I'm going to leave my contact information here, and I'm also going to open a poll with a few questions as well as some information about the complimentary lease review. But feel free to join us here at our website. You can visit us at www.cirrusconsultinggroup.com. And on that website, there are a tremendous amount of resources for dentists and dental practices across North America looking for more information on certain aspects of your lease agreements. If you want to learn more about your specific situation, about your lease agreement, visit the website. It has a lot of information, a lot of resources for people to read. We get featured, write blogs, write editorials, articles. Really, we really try to pull together everything for you on that website. So I encourage you to take down my information. Feel free to give us a call. Give me a call, send me an email, whatever works for you. And really, I do hope you got some value out of today's webinar. We certainly do appreciate your time. Looking forward to speaking with you soon, and I'll go ahead and